once the endpoint has been detected. When they develop a tumor, and this tumor is detected, the rats are euthanized. They are not kept alive for months, 6 months, 12 months, 18 months after that tumor is detected, as Saralini did, in order to produce massive grotesque tumors to produce photographs for public relations campaigns. This is a matter of record. A good colleague and friend of mine, head of the NIH office, that supervised this information, and that's the fact.
Thank you. I think that's a difference of opinion.
Yes, there's that, and I would just like to speak to the...
Well, can we just,
Wait.
I've got another witness here. And,
Could I ask a question first before we go to the other meeting? It's just a question, a procedural question.
yes, sir. Ma'am, whatever.
Thank you, whatever. I'm just, my understanding was that we were going to be talking about the constitutional and legal issues and not the issues of whether or not they're safe and whether or not they're, so I'm just a little confused
Okay,
about what.
let me try to clear that up.
Okay, thank you.
All right. The FDA says basically, and I'm paraphrasing now, that things have to be safe in order for them. They have to be as safe as traditionally bred plants. So that's the FDA has never said that there's any danger from genetically modified organisms.
Right.
GMOs. And so, given that, these two gentlemen have offered time here to discuss a little of the science, because when the case goes to court, and notice I didn't say if,
Right.
when the case goes to court, part of the issue will be, Mr. Hansen, I guess, would argue that they're not safe. Mr. Giddings would argue that they are safe, and that'll be part of the argument. So I think it's important for us to...
It is important, I'm just confused because we heard that they're not safe side. I mean, they are safe side, but we didn't hear that they are safe side, but we heard
Well, I
the
would disagree with
constitutional
that.
and legal issues.
We heard about 35, I would disagree with that, as
Okay.
Senator White. I don't agree with that we haven't heard anything
No,
about
I meant in this
unsafe.
debate right here. That's all I meant. Is in this debate.
Well, you
Okay.
got me a little confused now.
Okay, so shall we hear from...
Yeah.
Mr. Abramson, we're ready for you now to speak to us. We have the Senate Judiciary Committee here and a full room of persons who are very interested in this bill. So if you could go ahead, that'd be great.
Thank you, and good morning. Appreciate the opportunity to testify this morning on behalf of the Biotechnology Industry Organization about the pending legislation in the state of Vermont. And I apologize for not being able to be there in person, but appreciate your willingness to hear me over the conference line. I guess I would start out by saying that my concern and the concern of the Biotechnology Industry Organization with a bill such as the one that's being considered is that, first of all, we don't believe that there is any factual basis to support the compelled speech that would be required under the bill. We would be concerned, I think, also that a number of the findings that are identified in at least in the version of the bill that we reviewed, are really either factually incorrect or misleading. And that, in turn, leads to one of the major issues with the speech that would be compelled under the bill itself, which we believe would also be misleading. And that's particularly problematic given the fact that, by all appearances, the purpose of the bill is to better inform the consumer so that the consumer can make a choice. So we don't see that this bill supports that goal. In fact, on the contrary, it undermines the goal of allowing consumers to be well informed and to make an informed choice in the marketplace. So that's just kind of a 30,000-foot overview of our concerns. But we think that these are not just our concerns. We think that these are concerns that are shared and have been shared publicly by the Food and Drug Administration and other bodies. I think that perhaps I should begin by just pointing out that contrary to some of the statements that have been made in the findings, there's no question that there is federal law and has been federal law on the books for decades that speaks to the food label. And that applies regardless of whether the food was produced using genetic engineering or traditional breeding techniques or any number of other production methods. It's irrelevant. And that is, in fact, the fundamental premise of the federal government's food safety program. All food is supposed to be safe, regardless of the production method. And the FDA has said very clearly that the mere fact that food is developed using a new method of production, let's say biotechnology, is really irrelevant. It still has to pass the exact same safety standard as any other food on the market. That's really critical. And when it comes to labeling of food, again, there's no separate standard for biotechnology-derived food or food produced by any other method, whatever that might be, or food produced in a certain area of the country versus another area, or food produced using migrant labor or not produced using migrant. That is absolutely irrelevant as far as FDA is concerned. The standard is the same. Anything that is on the label or the advertising of the food, what they call labeling, it is a violation of federal law for those statements on that label to be false or misleading in any particular. If the label is false or misleading in any particular, then the food is misbranded. And if it's misbranded, that means it can be taken out of commerce. That standard is absolutely clear. And so FDA's position, based on the science, is that it doesn't need to say anything different about food because of the production method. That federal standard is absolutely clear. And if a state decides to move into that sphere of deciding what should be placed on the label, there is that risk that it would be contrary to the federal standard. Now, the FDA has spoken about biotechnology-derived food, and I guess I should point out that I was in the executive branch during the 1980s when the federal government wrestled with the issue of what to do with biotechnology-derived products, all biotechnology-derived products, not just food products. And at that time, we felt that we were being told, on the one hand, that there should be an absolute ban on any biotechnology-derived products until all questions had been answered. On the other hand, we were being told by quite a few credentialed scientists that there was absolutely no reason for any special attention being paid to biotechnology-derived products at all. I think the executive branch probably did the right thing in retrospect. I mean, what we did is we went right down the middle, and we said, well, we are going to pay attention to it, but what we're going to do is we're going to say that biotechnology-derived products, whether they're pharmaceutical products or food products or any other type of product, have to be held to the exact same safety and environmental and public health standards as any other comparable product, period. That's what we decided. And all of FDA's statements since that time have been based on that fundamental principle. So when it came to issuing the agency's 1992 policy, FDA's 1992 policy on foods derived from new techniques, not just biotechnology, by the way, but foods derived from any new techniques, FDA made it very clear that there was no scientific basis whatsoever to distinguish those products, and furthermore, that there was no scientific basis to distinguish the labeling. Now, that's a final policy statement. That's not a draft. It's not a guidance. It is a policy statement which has never been changed by the agency and stands today. So FDA is absolutely clear on that point. And in the case law, that point, the most significant case, of course, nationally, on the issue of labeling associated with biotechnology have come forward, not just in the United States, although the National Academy of Sciences has been very consistent in its position on biotechnology-derived food products, but also from, of all places, the European Union. Many people, of course, realize that the European Union is particularly difficult when it comes to their standards for new products on the market, because they feel that consumer choice and consumer preference can trump safety determinations. That is not a position that the United States accepts. The United States has been very vocal on that point, and it has actually won decisions in the World Trade Organization on that point, but nonetheless the European Union persists. But it's the European Union's own body, the Directorate for Director General for Research, that has done the meta-analysis, which, by the way, is a matter of public record. They did the meta-analysis for over 400 EU member country-funded studies, spanned 2001 to 2010, which found that GMOs, that's the term that they use, are no riskier than other agricultural production methods. That's exactly what our own National Academy of Sciences has found. So it's not just the FDA position, it's supported by these scientific bodies world over. I'm sorry, someone had a question.
Actually, I wanted
Senator
to...
Sears.
This is Dick Sears. I chair the Senate Judiciary Committee, and
Yes,
appreciate
Mr.
your
Chairman.
testimony, sir. And I'm trying to bring this back. We have kind of a panel, and unfortunately, you are on the phone, and so you can't see the rest of the panel. But it's Dr. Hansen from the Consumers Union and Val Giddings. Dr. Giddings is, you may know him, from Silver Springs, Maryland, Information Technology and Innovation Foundation. I'm trying to bring the panel back to understanding. I think you're giving us what would be argued in a court of law should Vermont pass H112. Is that accurate?
Yes, that was my intent.
So the argument would be,
by the way, I know them both.
But so if I could ask a question of perhaps all three of you, then I'm going to phrase it in a Vermontism. How big a deal is the FDA's failure to either say it's good or bad, that they've never actually come out with any definitive ruling on GMO plants? And is that the basis that the state of Vermont would have to struggle with? And you're going back to the Amistoy decision in RGDA regarding curiosity. I think of all the things that worry me as chair of this committee, it's that particular point where, because we're up against it, the quote that I have here is, food and food ingredients derived from GE plants must adhere to the same safety requirements under the Federal Food, Drug, and Cosmetic Act that apply to food and food ingredients derived from traditionally bred plants. So if we could kind of look at that issue.
Senator, I would refer to Stan, but my sense is that it's not correct to say the FDA has made no definitive ruling here. The FDA has, following the U.S. National Academy of Sciences and authoritative bodies around the world, found that there is nothing about the use of recombinant DNA technologies in the production of improved crops or foods that tells you anything at all about the safety of these crops. The FDA has in fact examined specific cases more than 80 times where companies have put novel foods improved through biotechnology on the market, and they have failed to find any indicators of hazard or health risk. The argument has been made by some that FDA's consultation process is voluntary and therefore it is worthless, but the very same products have been reviewed under mandatory regimes by the European Union, in Canada, Japan, Korea, Australia, New Zealand, around the world, and the decisions of these regulators have invariably upheld the decisions reached by FDA. I don't think it's correct to say the FDA has not taken a definitive stand here.
And we just heard from you on the phone, Mr. Abramson. Would you agree with that?
Yes, Dr. Giddings is correct.
Okay. And Mr. Hansen, your opinion
Yeah,
I realize you're kind of the lone wolf on the
yeah.
panel, but.
I disagree. I disagree. The FDA hasn't made any conclusions themselves. When they say that this food needs to meet the standard of any food on the market, that's correct. Companies are not allowed to put unsafe foods on the market. But what our law does is, if that happens, they can be gone. They can be gone after the fact. What's different about genetic engineering is there's global consensus outside the United States. There's global consensus that genetic engineering differs from conventional breeding, raises safety issues, and that's why safety assessments should be required before the crops come on the market. That is functionally written into WTO because the Codex Alimentarius, which is the food standard setting organization of the UN, there was an 8-year process where these documents came out. They even tell you how to do safety assessments, what should be in them. The U.S. was there at all those meetings, and the U.S. view did not prevail. I should point out that Codex standards and guidelines, everything, they're written into they're considered trade legal. They're functionally written into WTO. So we don't require any difference. As for those FDA, the voluntary safety consultations, companies get to decide what information they put in and how they do it. The FDA does not actually analyze those and say we agree or disagree. They just get a letter that says we understand the company thinks there's no problems. And then finally, I would point out that the FDA, in fact, has contradicted themselves in the 92 policy because in 2001, as part of their pre-market biotech notification policy, where they were going to require the companies to notify the government of 120 days before commercialization. As part of that rule, they said we are going to require data from the companies, right? And that's because there was a difference, and I will just read from the Federal Register notice in this rule, quote, because some rDNA-induced unintended changes are specific to a transformational event, e.g. those resulting from insertion or mutagenesis, FDA believes that it needs to be provided with information about foods from all separate transformational events, even when the agency has been provided with information from foods from rDNA-modified plants with the same intended trait and has had no questions about such foods. In contrast, the agency does not believe that it needs to receive information about foods from plants derived through narrow crosses, end quote. That's traditional breeding. They just said we're going to require data from foods that come from our DNA and not from conventional breeding. That's a recognition that they're different. It's an implicit recognition that there's a safety issue. Otherwise, why would they be requiring that data? So that this 2001 policy contradicts the 1992 statement of the policy, but neither of them have been finalized. They are regulating under the 92 policy, not under the 2001. And furthermore, that's why I would argue that if this law is passed, you are not going to see a lawsuit or a potential challenge, because I think the companies know they would win. And I would further say, if the companies thought they would win, then why didn't they let, for example, Proposition 37 pass and then argue it in court? The companies have spent $70 million in the last 2 years, $48 million in California, $22 million in Washington State. If these ballot initiatives and laws are not constitutional, why spend $70 million in 2 years? Just let one of them go through and go to court and you get your decision.
Would either of you like to answer that question?
Yeah, well, first of all, let me just say on behalf of the Biotechnology Industry Organization, we're not going to speak to issues of why we do or do not challenge, anti-biotech statutes or ordinances. Our position on the law and the legality of these provisions has been absolutely clear and absolutely consistent. But I want to go back to some of the things that Dr. Hansen said, because as someone that's been involved in the submission of scientific data to FDA, I can tell you without any question that if FDA feels there are unanswered questions with a particular submission, they will absolutely ask for more data, and they have done that routinely. It's only after they have seen all of the data that they're interested in, and after they have made their own independent review of information, that they will issue what they call a no further questions letter, which is exactly what it means. We've seen what you have to say, and we have no further questions. I would also respectfully disagree with Dr. Hansen's view of the inconsistency between the proposal, the rule that was proposed in 2001 by FDA, and their 1992 statement. And I will tell you that the biotechnology industry absolutely supported the proposal that FDA issued. Why? Because the biotechnology industry is already providing that information to FDA. There was no additional burden placed on the industry. The reason why we felt that we wanted to support it was because it would have addressed all of these questions that the process is only voluntary. The process is voluntary only if you don't want to market any food. If you want to actually market the biotechnology-derived food, you have to go through that process because the food industry simply won't accept your product. That's just the reality of it, and our trading partners won't accept it if you haven't gone through that process. So to say that it's voluntary is really legally accurate, but as a factual matter, it's incorrect.
Thank you.
We just feel that if a statute such as the one that you're considering were to be passed at the state level, not only would it be a violation of the First Amendment of the Constitution, but a number of other constitutional provisions. I mean, you have an equal protection, a serious equal protection issue, because clearly your ordinance treats similarly situated groups differently. Now, Dr. Hansen will say, well, they are not similar. But all of the various scientific bodies have made it very clear that these foods are, and the data makes it clear, that these foods compositionally and nutritionally, if not identical, are absolutely similar. But yet your statute treats them as if they were different. And you treat different groups as if they were different.
Let's get another question.
There's another question. Thank you. I think I understand your concern about the bill that's before us. I want to say that, just for your information, there are a lot of people who don't necessarily trust the FDA's rule in a lot of these areas. So, as of recognizing that it's the federal government, Vermonters, there's a group of secessionists who would disagree with the FDA.
I appreciate your comment on that, Mr. Chairman. Thank you.
Senator Ash has a question.
I was going to say before, there's a part of me which wishes we were sitting in easy chairs drinking beers, watching this crossfire-like experience. Although staring at a phone might not really be very enjoyable. My question actually is for Val. When you began speaking, you were talking about you're as concerned about what you're consuming as any other consumer, and referenced a family member with a peanut allergy. So that's a sensitivity. And I guess my first question is a technical one, which is, let's say there is a peanut gene that is incorporated into, say, a tomato product. I'm not sure if that's something, although on the FDA's website they actually say that's the type of thing that can happen. Should that be noticed somewhere on a package so that consumers like you can be aware of that?
Absolutely, Senator. That should be on the label. If you take a gene from a crop or a food that is a known human allergen, and if you put that someplace where it's not commonly found, you have to make sure that consumers have the opportunity to learn about its presence on the label. And you know what? That's required under existing FDA regulations.
So
it is already a matter of law that must be on the label.
That's why it was a technical question. I don't think you really need to answer that. My second question really gets to a different one. And at first, a comment. Before you were saying the proponents have certain motivations. And I think what you meant was some proponents.
That's correct.
Right. Because people have different reasons for supporting it. And we're legislators, despite the fact that lobbyists run this building probably the same they run almost every other building in this country. Legislators have our own obligation to understand the issues and try and make our best judgment. So I want to be clear about that. But let's take the example of a salmon gene being imported into or genetically engineered to a tomato, which I think is also a concept that is not unthinkable. There may be people who, I'm not sure that salmon is a known allergenic, is it? All right, so maybe my example falls apart.
No, it is.
that it's an allergenic, which
Yes.
means you would be required to live.
Finfish are a known allergen.
So that would be required.
But there's only 8 that the FDA talks about, so,
Are there,
only 8 classes.
well, let me ask it in a different way, because I don't want to get into a fascinating but perhaps not productive debate between the two of you from our point of view. Are there fish genes which are at current time being engineered into other consumer or other consumable products that are not allergens?
Well, Senator, the short answer to your question, the answer I think you seek.
I'm not seeking any answer, just you know better than me.
My knee-jerk reaction to that question would be that I think the answer is no. I don't know all the research that's being done in all the labs around the world. It's possible that one could take a gene from a finfish, which is not itself encoding a protein known to be allergenic, and put that someplace where it wouldn't normally be found. That's certainly possible. I'm not aware of anybody doing that. But there's a more fundamental problem with the way you framed the question. And if I could address that, it's relevant to this. A lot of folks who are concerned about these issues, I do not question the sincerity of their concerns, but the concerns, to the extent that they think that they are concerned because of safety issues and because of something which is unnatural and so forth, those concerns are not supported by the data. They're not supported by the science.
But what if someone just doesn't want to eat fish?
If someone just doesn't want to eat fish, they have the option to avoid eating fish.
Even if it's not a known allergen, and it might be
Here's the
incorporated into a product that a reasonable person would
Here's the issue I wanted to address that is raised by your question. You spoke of a fish gene. In point of actual fact, a gene is not a fish gene or a daffodil gene or a human gene. The single most common gene in your body, in my body, in the bodies of every one of us in this room, the single gene that is most common in our genomes can't be called a human gene. It originated in a virus. It's called ALU1. It's a transposal element that evolved in viruses, and it made the leap into our mammalian ancestral lineage sometime in the distant past. But it's not a human gene, except to the extent that it's found in humans. But it's found throughout all sorts of other taxa. There's nothing in a DNA sequence that says, I belong only in humans, I belong only in fish, and any place else that I might be found is unnatural. 98% of the genes that we have in our human bodies are also found in chimpanzees. 25% of the genes in our bodies are found in Drosophila. So DNA...
Well, I'm getting like Frankenstein images of like a cannibal isn't a full cannibal. They're
I want to go back to your
2%
question.
of a
If
cannibal.
you asked the question in a different way, I think it might be helpful.
No, I'm getting kind of the flavor. I'm wondering about the cannibal though, who eats another person. They're only actually eating 2% of a person, 98% of a virus that's in everything else.
The cannibal eats another person who's eating another person, but the DNA that he's consuming, it's...
I got you.
This committee is against
Most of us are.
The biotechnology industry organization is as well.
We found something all of us agree on.
We did not take a show of hands.
Senator Ash.
I guess my musings have been responded to. Interesting.
I think with the few minutes that we have left, I wonder if, starting with Mr. Abramson on the phone, if you could sum up in a couple of minutes what issues you see in this bill, given that you oppose the bill, but are there things in the bill that you think would improve the bill? And I realize it's a tough question to ask an opponent, but what would you do to improve the bill?
That's an interesting question. I think that what I would do to improve the bill is, rather than compelling speech, which is misleading, which is what the current bill does, I would look for a bill that puts a reasonably small amount of money into education. Because quite honestly, I think that as a society, we have not really fulfilled our obligation, particularly to our young people, but also to the consumer, to provide education on some of the new techniques that are being used to deliver consumer products. And I think that that's where the most benefits lie. North Carolina has actually done a very good job in reaching out to the public schools with education, and this has clause, due process, federal preemption, all of those challenges are raised by a bill like this. But let's try and provide, unbiased information to the consumer and to young people about new technologies. That would be what I would do to improve the bill. Thank you for asking.
Well, thank you very much, Mr. Hughes.
Stan Abramson is correct.
Thank you. Mr. Hanson, anything you do to improve the bill?
From what I've seen, the bill is fine as it is, except that one way to improve it, it's my understanding that I know that the House version had a trigger with multiple states, and that the Senate version does not. I would say that make sure that that trigger provision with multiple states is not in anything that finally gets voted out here.
Well, then, to putting, thank you, that's helpful. The three of you have been very helpful for me in trying to figure this morass out. But let me just say that these are never simple decisions, but appreciate your willingness to come forward and be here today. And thank all three of you. Appreciate it very much.
Thank you.
Thank you.
Thank you, Mr. Chairman.
Thank you very much. And committee, thank you, and I didn't mean to get into a debate over it, but I think that we've heard so much from, I need to understand too the basis of the lawsuits, and that's what's helpful scientific information. And for all of you, the goal of the committee is to vote on the bill, whether you have 3 votes, 2 votes, 1 vote, or 5 votes. Sometime towards the end of next week. I think you certainly have had plenty of testimony between the public hearing and the thousands of emails. By the way, no need to continue the emails. We can just say that we're going to try to get the bill out by the end of this month, and hopefully sooner than that. So with that, I will conclude our hearing. I know that some members have to go to another meeting.